Family and fellow soldiers, I'm the Professor, and this is the Moment of Truth. Remember how I told you about trash like Christopher Rufo and how he works for the anti-black think tank Manhattan Institute? The same organization that employed and brought to prominence Charles Murray, who wrote the infamous hate tract, The Bell Curve. The same Manhattan Institute who put their resources into booking TV appearances for John McWhorter, who is a professional black self-hater. He's also a Manhattan Institute employee, just like Christopher Rufo is, and just like Charles Murray was for so many years. A lot of you wonder why we have these occasional bursts of anti-black racists who pop up out of nowhere as a group, and who seem to all have this exposure in the white media so easily. These are anti-black white supremacist operations that we've been seeing. These guys don't just pop up. They literally work for white supremacist organizations. And as the black media, part of our job is to connect the dots for you, to tell you who's sending these clowns. Because these guys are not grassroots at all. They're pure astroturf. Like those crisis actors who were at those school boards acting out, they're actually put there and sent there, in many cases being paid by these think tanks like the Manhattan Institute to do these things. And of course, their temper tantrum is planned and organized, it's deliberate, meant to get them some TV coverage, which then political reprobates like Ron DeSantis and Greg Abbott can point to and claim that this is going to be their justification for some sweeping legislation meant to outlaw the Constitution in total. It's a right-wing program that's been planned, paid for, and promoted by the same right white interests who have been doing all these other things. The same people who fund the Manhattan Institute are the same people who pay the crisis actors to go to the school boards and make a phony ruckus, and they're the same ones who prop up and fund anti-black racists like DeSantis and Abbott. And we see it in plenty of other places too. Like, take the Harvard lawsuit that's going on right now. It's the same kind of scam, orchestrated the exact same way. Now, I've talked about the right-wing lawsuit against Harvard based on its admissions policies before, but we can always use a refresher course, especially about the people behind this thing. The Harvard admissions lawsuit that's going on right now was manufactured and pushed by a guy named Ed Blum. And just like Christopher Rufo, he didn't just get up one morning and decide to file a lawsuit. He is a career right-wing operative. I've told you about him before. For the last 30 years, this guy has been paid to manufacture lawsuits specifically meant to target legislation that the Republicans are too scared to take on in the legislatures. And all the things his rich white donors pay him to file lawsuits about are exclusively about race and nothing else, and it always pertains to black people. His lawsuits specifically target things like voting rights or affirmative action or school admissions policies. By going through the courts, the GOP feels that they can avoid the political consequences that they would inevitably suffer if they tried to go through Congress or through a state legislature. So, how does this Blum guy operate? First of all, he doesn't file the lawsuits on his own behalf. Instead, he looks for people who he can use as fronts for these racial operations. And these are willing subjects, by the way. Don't think that a mental midget like this Blum character came up with this on his own. As the New York Times says, he's being bankrolled by wealthy right-wing donors, some of them huge corporations like Searle Pharmaceuticals. Searle Pharmaceuticals uses their money in order to bankroll a so-called Searle Freedom Trust, which is a 501c3, meaning they're tax-exempt. What they do is they use the Searle Freedom Trust in order to give money to all kinds of right-wing groups, organizations, and individuals. And who do they give that money to? They've given money to groups like the Manhattan Institute, the Heritage Foundation, and the Federalist Society. The Federalist Society's own website says that the Searle Foundation is one of their main donors. This is why I keep bringing their names up so much, Manhattan Institute, Federalist Society, so you can understand where these people who you've been seeing in these activities that have been going on, you can see where this stuff comes from, who's been bankrolling it. The Federalist Society, as I told you, was created in the early 1980s by right-wing lawyers and law students. Their job? Organize a gang of hardcore right extremists with law degrees who would then get money from rich white donors, and they would go to the GOP and say, put our guys on the federal bench, and of course the Supreme Court. It very soon became obvious that if you wanted to get a federal judgeship, the most sure way to get it was to convince the Federalist Society to sponsor your nomination. But lobbying members of Congress isn't cheap. It takes time, but most of all, it takes money. And that's where rich donors like the Searle Freedom Trust come in. So you see, this entire thing is rigged from top to bottom. This is the right wing's judicial activism operation that I told you about. They know they can't win in the legislature, so they realized 40 years ago that the judiciary would essentially become their last ditch. That's why the Federalist Society has spent 4 decades making a mission out of stuffing the federal bench with as many of their hand-picked lunatics as they can find. Professional litigants like this Blum character are always trying to shop around for the right judge to present their cases to. And thanks to the Federalist Society, they took the guesswork out of it. And Blum's lawsuit against Harvard, this isn't the first time that he's done this. This is actually part of an ongoing crusade that he's been waging without much success until the last few years. Blum's original attempt to try to misuse the courts in order to attack affirmative action took place in Texas. He recruited a white girl named Abigail Fisher. She was patently unqualified to flip hamburgers, much less go to the University of Texas at Austin, but she was a stalking horse and she gleefully served this purpose. And like all of Blum's other lawsuits, there was no actual grievance. He literally called his friends and asked them if any of them would like to be the front person for his judicial scam. As the New York Times reported, this is how this guy operates. He starts off with some legislation that he wants the Federalist Society stooges on the bench to strike down. Then he looks around asking if any of his pals want to be his pretend plaintiff for his lawsuit. This is the epitome of AstroTurf. Nothing this guy does is grassroots at all. His lawsuits are not the result of some actual grievance. It's wealthy right-wing interests who are trying to use the courts as an end run around the law. Wealthy racists like the Searle Freedom Trust will give money to the Federalist Society so that they can put some of their operatives on the federal bench, and then they pay operatives like this Blum character to run around manufacturing lawsuits that they can put in front of those judges. In the case of his failed lawsuits against UTA, Blum had a friend of his have his own daughter apply to the University of Texas at Austin, and of course she was turned down because, as the Times reported, Fisher was portrayed as a less than stellar student. First of all, she was a less than stellar student. She could barely pass a taste test, much less an admissions test. She's the epitome of white entitlement. And she wasn't vilified by anyone. She was correctly identified because she gladly signed on to what she knew was a racially motivated judicial stunt meant to do an end run around the law, the voters, and common decency. And she and Blum's fraudulent case failed not once but twice. Now this Blum character, he's been filing his nuisance suits for 30 years now, and for the most part he's been losing his cases. But that began to change in the last 10 years. The first lucky break for Blum came in the W administration, when W was able to put not one but 2 Supreme Court justices on the bench. This gave the right-wingers a one-person majority on the court, at least most of the time. The issue of race as a consideration for school admissions has long been a settled matter of law. Blum himself proved it when he lost not 1 but 2 of his nuisance suits on behalf of the dim-witted Abigail Fisher. So no one can deny that this was a settled matter of law with a long-standing body of law to back it up. The Supreme Court certainly considered it settled. After getting spanked twice on the Fisher lawsuits, Blum decided that he would try to gin up another phony case, only this time he would claim that it was for a non-white plaintiff, Asians in this instance, and that's the one that's heading to the Supreme Court now. It needs to be noted that Asians were not the ones who dreamt up this operation, though to be honest, I haven't seen too many of them opposing it either. This latest legal fraud hasn't really gone anywhere until now because while the alleged Asian plaintiffs of Blum's presumably have better grades than Fisher, it's hard to imagine someone with worse grades. The problem is that the Supreme Court ruled on all this in 2016, twice. And here he was trying to run back to them immediately afterwards. The court declined to hear his case because he doesn't have one. All he did was to reinforce that colleges and universities can use race as a consideration in their admissions policies for the sake of diversity. But now, suddenly, That same Supreme Court has decided to do a breakneck 180. And after decades of throwing out racist scam cases like Fisher's, only a few years after affirming twice that universities can consider race in admissions for the sake of diversity, now this Supreme Court suddenly decides that this latest iteration of the same fraudulent lawsuit should be heard. Keep in mind, most of the justices who are on the Supreme Court right now were the same ones who heard the Fisher cases only a few years ago. So what changed? In 2016, when Fisher's suit was laughed out of the court, the majority ruling was issued by Justices Anthony Kennedy, Stephen Breyer, Ruth Bader Ginsburg, and Sonia Sotomayor. Elena Kagan was on the court, but she recused herself, and even so, the right-wing nuts Roberts, Thomas, and Alito were in the minority, so they lost. However, it's been 6 years, and it's a different court now. Anthony Kennedy, Stephen Breyer, and Ruth Bader Ginsburg are no longer there. Trump replaced them with hardcore Federalist ideologues like Gorsuch, Kavanaugh, and Barrett. There's no longer an on-again, off-again, one-person right-wing majority on the court. Now they have 6 hardcore, mouth-frothing right-wing zealots. This was why the Federalist Society was created. And at long last, they've achieved their goal, to turn the Supreme Court into nothing more than an extension of the Republican Party. Obviously, with the right-wing supermajority on the Supreme Court, they understand that this is the last opportunity that they're going to have to try to give a new lease on life to a lot of the laws and policies meant to uphold white privilege, and their last chance to roll back some of the admittedly modest changes that have been made over the last 50 years. That's what this has all been about. But you didn't have to wait until the recent dust-up about Roe v. Wade or even the now-resurrected Harvard admissions cases to see that this was coming. The right-wing nuts went ape when Obama was elected in 2008, but the wheels really fell off the loony wagon when it became more and more obvious that he would easily win re-election in 2012. Obama's election scared and infuriated the white supremacists because of what they felt that it symbolized for the country as a whole. Now, the Republicans then as now controlled the majority of state legislatures, but Obama's presidency reminded them like nothing else had that they were living on borrowed time. Sooner or later, all of those red state legislatures that the GOP had controlled for so long would one by one begin turning blue, and there would be nothing the GOP could do about it, unless they acted to change voting regulations. And so in 2011, a year before the 2012 election, Ed Blum began searching for a lawsuit that he could use to justify eliminating the pre-clearance clause of the Voting Rights Act. For those of you who don't know, the core of the Voting Rights Act happened to be its pre-clearance statute. It required that southern states, the states of the old Confederacy, had to submit any changes to their voter district maps to the Department of Justice to be scrutinized and approved. This had always been a huge sore point and a grievous offense to the GOP because it prevented them from carrying out the kind of anti-black voter purging and voter caging that they had been doing before the Voting Rights Act was passed. Ed Blum began looking around for someone who he could use as his stalking horse for this political operation, and he found his sock puppet plaintiff in the government of Shelby County, Alabama. So on their behalf, Ed Blum sued Obama's Justice Department with the claim that America had changed and there was no need for the Voting Rights Act's pre-clearance statute anymore. Why, the southern states were no more racist than the northern states, and it's time for all that to end. And what was Ed Blum's evidence? Why, there are all these black politicians down south at the city and state levels. And since there are all these black politicians, we no longer need the law that made it possible for these black politicians to get into office in the first place. It was a circular argument. Everyone knew exactly what it was. It was time for the Federalist Society's sleeper agents to finally wake up. So in a ruling that the right-wingers on the bench admitted was purely based on their own prejudices and biases, in a ruling that was split strictly on ideological lines, the Supreme Court struck down the pre-clearance provision of the Voting Rights Act. And the very next day, red states began passing laws to redraw their voting districts. And they were not at all bashful about why they were doing it, to target black voters specifically. And the GOP's anti-black racial scheming was so blatant, so egregious, that in 2016, a federal judge struck down a North Carolina voting law because, as the judge put it, the new provisions target African Americans with almost surgical precision. Now, while all this was going on, the Democrats were saying that if only people would let them have control of Congress back, why, the Democrats would do something about all this. But as we all know, black voters gave the Democrats control of both houses of Congress and the presidency 2 years ago, and they haven't done anything about it. This is a racial agenda, and the people carrying it out know it. It's all out in the open. That's how blatant they are about it. Who the rich donors are, who their front organizations are that they use to float money to the right-wing operatives that they fund and control. These rich white donors, they have set up a rigged judiciary. They fund the Federalist Society, whose job is to ramrod right-wing extremists onto the federal bench, and these same rich white interests then bankroll parasites like Blum, who manufacture phony lawsuits that allow their judicial activists that they put on the courts to carry out their extremist agenda. And since federal judgeships are for life, you don't have to worry about term limits, or better yet, that unlike Congress, you don't have to worry about the voters voting out a judge who decides to violate the Constitution. Antonin Scalia, may he rot in hell, even admitted that this was blatant judicial activism, legislating from the bench, in his opinion on Shelby v. Holder. In fact, Scalia came out and admitted that he and his Federalist Society fellow stooges considered themselves to be a super branch of government, and that they were more suited to decide what the nation's laws should be than the Congress. He actually said that. Now, before I give you some of Scalia's quotes, I need to preface it by pointing out that the Voting Rights Act had to be renewed every 25 years, and it never failed to be renewed even once in all that time. Scalia whined about this like a baby in his opinion. Quote, "This last enactment, not a single vote in the Senate against it, and the House is pretty much the same. Now, I don't think that's attributable to the fact that it is so much clearer now that we need this. I think it is attributable, very likely attributable, to a phenomenon that is called perpetuation of racial entitlement." Now, keep in mind the scumbag Scalia was a member of the judiciary, not the legislature, and for him to say racial entitlement is asinine. There's only a handful of black congresspeople, not that they're worth a rip. And in 2013, Obama was in the White House, so I don't recall there being any black senators. So who exactly is promoting and protecting this entitlement? White supremacists are always projecting onto everyone else, but as you see, Scalia was telegraphing clearly that his ruling wasn't going to be based on law, facts, or even reality. It would just be a right-wing editorial masquerading as a judicial opinion. Scalia continued by saying, "I don't think there is anything to be gained by any senator to vote against continuation of this act, and I am fairly confident it will be reenacted in perpetuity unless a court can say it does not comport with the Constitution." So, he'd gone from pretending to be a member of Congress to now being a fortune teller. Antonin Scalia thought that he was Nostradamus. He could see the future. Why, he knew that the Voting Rights Act would be continued in perpetuity, forever and ever. But the most telling part of his little tirade was when he said, "unless a court can say it does not comport with the Constitution." That is what you call legislating from the bench. A judge cannot legally strike down a law unless the Constitution is on his side. And at no point does he even bring up the Constitution because he wants to make it very clear. He wanted to tell everybody that's not what this is about. This is about white rule. This is about making sure that black people are in their place. You see, normally, at most, all a judge can do about a law that they disagree with is to say that, well, if the legislature were to pass a law saying XYZ, then there would be grounds to strike it down. But aside from that, I can't do anything. Basically, all they can do is the judicial equivalent of saying there ought to be a law. But Scalia wasn't done. He went on to say, "It's a concern that this is not the kind of question you can leave to Congress." This is him showing his behind with a blatant statement of contempt for the U.S. Congress. Scalia made it clear this wasn't about the law. This was about the right-wingers on the court acting as a super branch of government. You can't leave legislating to the legislators. You need an unelected, unaccountable group of ideologues to be in charge. He declares that his right-wing pals are taking it upon themselves to govern the country according to their own political ideology. And why? Because the Congress won't do what these right-wing lunatics want it to do. Apparently, governing is simply too important to be left to Congress. The judges need to be the ones in charge. Finally, Scalia admits to his political high-handedness when he says, and even the Virginia senators, they have no interest in voting against this. The state government is not their government, and they are going to lose. They are going to lose votes if they do not enact the Voting Rights Act. This is paranoia on a grand scale, but it's also a summation of Scalia's pretentiousness, his pretending to be a fortune teller, and his naked contempt for Congress. How can he say that these senators have no interest in voting against the Voting Rights Act? Did he talk to them? Did he ask them? Did he ask any member of Congress what they thought about the Voting Rights Act? Did he talk to the constituents of these senators? How does he know that these senators would lose votes? But his admission is a confession that these right-wing nuts know their political stance is not popular with the American people. They're going against the will of the public, and they know it. Scalia admits it. He admits that the Voting Rights Act is popular with the American people. And if the congressmen decided to vote against it, they were scared that the people would vote them out. Well, you know what you call that? You call that democracy. Isn't that what you call rule by the people for the people? But the Federalist Society flunky Scalia, he declared, no, this is going to be legislating from the bench, where it's going to be the rule by the few for the few. Scalia's entire putrid career was the epitome of racial entitlement. If it wasn't for his race, that mental midget wouldn't have been a judge in traffic court, much less the Supreme Court. But this is the court as it stood in 2013. And they were a slim one-vote majority on the bench then, and as we all know, the right-wing nuts added another seat to their number in 2020, so they no longer had to worry about any swing vote that might not go their way. They've become emboldened by their fluke majority on the court, but they're also scared. Clarence Thomas is old as hell, and you can tell that his health ain't the greatest. They know which way the demographics are going, but more importantly, they can tell which way that the black street's going. They know they've got to do something bold, something dramatic to prop up white privilege just a little bit longer. Scalia admitted it himself. The voters won't allow these policies at the state level. So you got these extreme right-wingers, they need a means to enact their right-wing racism without having the public able to influence it or to punish them for it. Well, people are focusing on the courts now, which is a good thing. The problem, however, is that this scrutiny isn't because of black people. That's the real problem. It's not being done because of the things that have been done to harm black people through the Supreme Court. These white leftists, they're only up in arms because there's something at stake that pertains to them. And they're determined to make sure that the conversation goes no further than that. Oh, once they go ahead and get this whole abortion on demand thing settled, well, that's going to be the end of that one. We have no friends in this fight. But if you want to know what's behind the Harvard admissions case as well as these other cases, now you know. And we have to make it known that black empowerment will hand down the final ruling on these white supremacist machinations from the white left and the white right. And if we have our way, no one will be able to overturn that. Good day, and be one. I'd like to take a moment to mention some of our contributors. Sabrina, Stephen Mugisa, Racer Bo, Dave Dawn, and Philander Bryant. Salute to them and thank you to everyone for listening, liking, and sharing this message. Black empowerment only exists because of you.